Thank you, Chair Perry and Ranking Member Titus for calling today's hearing. We're here to discuss safeguarding our democracy, to strengthen our democratic institutions, and Congress's responsibility to maintain its Article I power as a co-equal branch of government. So regardless of the sitting president's political party, Congress needs to conduct oversight of emergency powers used by the executive branch. Now, we'll say in reviewing the testimony from today's panel, it was eye-opening and jaw-dropping. The breadth of the president's powers and the struggle that Congress has been through since 73, 76 in order to try to define a fence, if you will, around those powers. A core tenet of the Constitution is a system of checks and balances, which ensures that no one branch of government has too much control or power. That includes checking the powers granted to a president during national emergencies. This nation does grant extraordinary powers to the president during national emergencies. Presidents can determine what rises to the level of a national emergency and declare such emergency without the approval of Congress. A national emergency declaration in turn unlocks more than 130 standby authorities for the president, even if they're not relevant to the emergency at hand. Congress conducted extensive oversight regarding the president's authority to declare emergencies in 1973, and a Senate special committee was appointed to investigate concerns that national emergencies were active for too long and that no congressional mechanism existed to terminate them. I was surprised they actually set this up to look at national emergency powers that were established under the Korean War, and then discovered there was a lot more out there, which caused a lot of concern for Congress. So these emergencies were active for too long and no congressional mechanism existed to terminate them. So the committee report resulted in the passage of the National Emergencies Act, which formalized the emergency powers of the president, authorized Congress to biannually review these emergencies, and then vote to terminate presidentially declared emergencies as well, which was the Supreme Court in 1983 removed as an unconstitutional legislative veto. But today we exist in arguably what the National Emergencies Act was designed to avoid, a perpetual state of emergency. Currently, 41 separate emergencies are in effect. Presidential national emergencies are in effect. The oldest one pertains to sanctions against Iran, which has been renewed annually since 1979. I'm not disputing that subject matter of any of these national emergencies are not important. I'm only arguing that after reading testimony, and thankfully calling this hearing, that we do have an opportunity to examine whether addressing these issues in a manner that gives the president indefinite emergency level powers is appropriate. Look forward to discussing what an appropriate balance is. Congress is a deliberative body. It does take us time to deliberate and get things done. I can understand why a president needs authority to react quickly in a true emergency and protect the public, because Congress is slow to react. But in the long term, emergency powers should not be a convenience that is used to circumvent congressional action. And we'll argue and debate what is appropriate and what is not appropriate. Again, it's really an issue of whether or not, or when a national emergency is declared by the president. What can Congress do to put some bounds around that? So the witnesses are clearly highly qualified, much more than me, to discuss this issue for us. But as I always say, I'm not an expert. I'm a member of Congress, and I rely on the experts to close that gap. So I look forward to today's hearing and hearing from our witnesses. With that, I yield back.